morning, Ms. Lento. Good morning, Ms. Strong. Good morning, Your Honor. Mario Gallucci on behalf of Mr. Greger, who is seated to my left.
Good morning, Mr. Greger. All right, the jury is not present today. They're scheduled to report tomorrow. Given the fact that the parties are close to concluding, we discussed having a charge conference. The court will conduct this charge conference pursuant to Rule 1:8-7, subsection B. The entire conference is on the record, and no part of the charge conference will occur off the record. The court previously provided all counsel with a copy of a draft final jury charge, and also provided a copy of the model charge on endangering the welfare of a child, abuse or neglect, because there are various portions of that charge which likely need to be edited or deleted because they're likely not applicable to the allegations in this case. In addition, separately, the state over the weekend filed a notice of motion to bar certain opinion testimony by the defendant's medical expert, Dr. Michael Baden. Specifically, the state does not seek to bar the doctor's entire testimony, but seeks to bar certain comments from Dr. Baden's report, which it believes are beyond medical testimony and instead would invade the province of the jury to be able to decide disputed facts that are allegedly within the knowledge of the average juror. Mr. Gallucci, is that something we can also address today, you think?
No. I have Ms. Ferranti working on it. She's working on a response to that. She's going to try to get a response to the court, within a day or so.
Okay.
And then we'll be prepared to argue it.
All right. Very good. All right. With respect to the jury charge, does everyone have the draft charge?
Yes, Judge.
All right. And how would you propose going through this? Just page by page?
Whatever you prefer, Your Honor.
All right. That's typically, I haven't marked this as an exhibit yet. You should mark it as a court exhibit, I guess. And then we could revise it. Madam Clerk, what's the next in order?
C13.
S13? Or C13, excuse me. C13 is the proposed final charge. Currently it is 26 pages. Any objections to or comments or additions to pages 1, 2, 3, and 4?
Your Honor, there's no objection from the state. It appears to be right from the model charge, so.
Right.
No, Your Honor, nothing from the defense side.
All right, so everyone knows the charge is generally divided into 4 parts. So pages 1 through 4 essentially is part 1. Part 2 is on the evidence the jury can consider. Any objections to page 5, sections entitled direct and circumstantial evidence and credibility of witnesses, which continues on to the top of page 6.
No.
There's no objection, Judge. Thank you.
Thank you. On page 6, middle of the page, the section entitled written statements of defendant. In the first sentence, I was thinking about trying to clarify that we're really talking about written statements in electronic form as opposed to letters or typewritten documents or something, because it's been some time since the jury heard that. So I guess I would propose adding, I'd be happy to hear from counsel, but I would propose adding there is for your consideration in this case, various written statements in electronic form allegedly made by the defendant.
Judge, I had a note with something to that effect as well.
We had text and emails, Your Honor, but
Electronic is all encompassing.
Is that acceptable, Mr. Gallucci?
Judge, I don't know if I necessarily want you to steer the jury into looking at particular pieces of evidence. I think that this is fine the way it's drafted.
All right, I certainly don't want to steer into particular pieces of evidence, but is there a written paper statement of the defendant?
Not that I know.
Right, so it's all in electronic form, so I'm just trying to clarify what that, because oftentimes you may have a, defendant signs a written confession or something like that, so you object to change that?
Yeah, I think that this is fine the way it's written.
What's the state's response?
Judge, I think that we're supposed to tailor the jury charge where appropriate and not use the model, and I think it's more appropriate. I think it's misleading. There's no written statements, handwritten statements in this case. There are electronic statements in the case, and I think it's an appropriate tailoring of the charge there.
Judge,
One
if you
word.
just want to change that one word, is that what you're asking? Just one word to electronic statements?
Well, I'm still going to leave written, but I was going to say written statements in electronic form, or I can just put written electronic statements, add one word, you know.
That's fine.
All right, yeah, so I'll do written electronic statements, okay. All right, the bottom of 6, continuing on to half the 7, oral statements of defendant. Any objection to that?
Have anything?
No. No.
No, Your Honor.
No, Judge, thank you.
And again, that's a model charge.
I have stuff here.
Bottom of 7, redacted recorded statement of defendant. This, I believe, relates to the DCP&P telephone call to the hotline. And there were some redactions, which is why we use this. Any objection or comments to that section?
No, Judge, thank you.
No, Your Honor.
No, take care of this.
Page 8, oral statements of Corey Michelow, which is all of 8 and just the first paragraph on 9. I have one minor typographical change in the 4th paragraph. In considering whether or not an oral statement was actually made by Corey, and if made, whether it is credible, I'm just going to change to whether it was credible, just for verbs tense. Any objection to that change?
No, Judge.
No, Judge.
Any other request to alter or change any part of that
Yes,
section?
yes, Judge.
Go ahead.
So, in the first paragraph, there is for your consideration in this case various oral statements allegedly made by Corey to Dr. Deacon. I would do comma, the pediatrician, so that the jury knows what we're talking about. And then I believe it would be,
You want to use your full name too, Nancy Deacon, right?
yes, Judge. Thank you.
Any objection to saying Dr. Nancy Deacon, the pediatrician?
No, Your Honor.
And then in future
Or
reference,
more accurately, of IB Pediatrics?
either one, Your Honor,
Is that okay, Mr.
would be satisfactory with the
Yes,
statement.
Judge.
All right, of IB Pediatrics.
And then in second reference, Dr. Deacon is satisfactory to the state. And then I believe it's the 6th paragraph, so it would just be the second from the bottom.
Right.
I know that there was discussion and argument about Dr. Deacon and cross-examination, etc. However, the state just objects to relating to the issue, including any prodding by Dr. Deacon, the characterization of prodding. I don't know that we agreed to that necessarily, or even discussed that portion of it at the time that there was the objection, and then the cross-examination, which her credibility wasn't really impeached with regard to that issue.
Mr. Glucci.
I disagree.
So, no one had asked for a hearing outside the presence, well, actually, we did have a hearing outside the presence of the jury with respect to Dr. Deacon, but no one had raised an issue of any type of suggestive questioning by Dr. Deacon outside the presence of the jury. The purpose of the hearing was to determine if the child was making statements which were present sense impressions where he described feeling pain, and or whether he made the statements for the purpose of medical diagnosis or treatment, both of those being under New Jersey Rule of Evidence 803C4 and New Jersey Rule of Evidence 803C3. During the course of the 104 hearing, she said that she had observed bruises, she had a chart of injury, and then she said Corey told her the bruises came by playing football with his dad, and he got more bruises from running on the treadmill. However, at trial, the first time she, when I say at trial, meaning in front of the jury, for the first time she disclosed that Corey didn't want to talk about it. He didn't want to say what happened. She then explained to him that she had to know in order to help him and to be safe. Atypically, at that point, the doctor started to become tearful and emotional, and what actually at one point was crying. She then said, Corey said his injuries on his chest, arm, and head were bruises from football. The doctor described pressing him further, and then he said he fell on a treadmill. In retrospect, I would have certainly preferred that testimony about Corey being hesitant and then being pressed, including that the doctor had to know this in order to help him and help him be safe, came out outside the presence of the jury. So in response to that, I included that language in there, which frankly, given the doctor's statements that she had to press him and had to tell him he needed to disclose these things in order to be safe, was pretty mild. So at the very least, I think that needs to be in there, if not including any prodding or suggestive questioning by the doctor. I'd analogize that to a 803.327, a child sex assault interview, where the state has to meticulously show that a child was not subject to suggestive or repeated questioning or prodding before the child made disclosures. But it was my attempt to address it since it came out, and really wasn't specifically objected to when it came out either, and I didn't expect it, and it was somewhat different than the doctor testified to at the 104 hearing outside the presence of the jury. So at a minimum, I think prodding needs to stay in there. Any response to that from either side?
The basis for my objection was just at page 91 of her transcript, line 5, so this was the testimony in front of the jury. So I said, Corey, we can't help you if we don't know what happened, and please, and don't worry, because, I need to know so I can help you be safe. And I had took it as assurances and reassurances because he was a 6-year-old boy that appeared to be scared. So that was just the explanation for why I had objected to the word.
All right. Mr. Lucian, anything to add?
Judge, I like what you just said. I think you should include and suggestive questioning in the charge.
Judge, the state objects to that.
I think it's appropriate for the reason I've indicated. I'm also concerned why the doctor didn't say that at the 104 hearing, because the hearing was about what Corey was saying. So why not say it then? It's not as if the hearing was on a different evidence rule, but nevertheless it dealt with Corey's statements. So why say it in front of the jury because it creates the impression somehow that the child was afraid to talk about it, which was something we should have dealt with in advance. So, and that paragraph, second from the bottom on page 8, including any prodding or suggestive questioning by Dr. Deacon. Top of page 9, the defendant's election not to testify, that's simply there as a placeholder in the event the defendant chooses not to testify. So, Mr. Bucci, just leave it there for the time being?
Yes, Judge.
All right. Middle of page 9, multiple charges. So the first paragraph is essentially the standard model instruction on multiple charges. The court gave this at the request of defense counsel after it was discussed on the record. After the opening statements of both attorneys, and it was marked as Exhibit C3 in evidence at the time on April 30, 2024. And it's intended to be not simply an instruction on multiple charges, but also to be a limiting instruction on the jury's ability to use any evidence of the endangering alleged in count 1 as for its consideration of the homicide charge in count 2. The only thing I was thinking is the end of the first paragraph needs to be amended a little bit because I was
Yes.
talking about it. So I'm talking about giving a charge later at the final charge in the case, and this is the final charge in the case. So that sentence should now read, at least in my view, in your determination of whether the state has proven the defendant guilty of the crimes charged in the indictment beyond a reasonable doubt, the defendant is entitled to have each count considered separately by the evidence which is relevant and material to that particular charge based upon the law as I am giving it to you in this final charge. And then crossing out at the end of the case. Is that acceptable?
Yes, Your Honor.
Judge, I'm sorry, what paragraph are you on? You're on the first one?
Right, so page 9, multiple charges.
Yeah.
The first sentence is there are 2 offenses.
Right.
The second sentence is those offenses are separate by separate counts in the indictment. The third sentence, that goes all the way to the end of the paragraph. The very end,
As I am.
evidence which is relevant and material to that particular charge based upon the law as I am giving it to you in this final charge.
Okay, thank you, Judge. There's no objection.
Okay. And any objection to the rest of that? All the way on to the bottom of page 10.
No, Your Honor.
No, Judge.
So one of the things I thought of in the beginning, and also in the rest of this charge, we sometimes refer to Corey and sometimes refer to him by his initial CM. Obviously, the state was required to do that early on. Do you want to try and make it consistent and just say Corey all the time, or?
Hey, Judge, I think it should be consistent. If you're going back and forth, I think it could give confusion.
Yeah, Judge, we have no objection to that. Clearly, that came out on the record. So.
We'll try and search and replace then CM with Corey. So then the multiple charges section on pages 9 and 10, Corey will need to be added after we remove CM. Expert testimony on starts on the bottom of 10 and goes on to 11. Any objection to that?
Yeah, true.
Judge, I would just ask that we refer to Dr. Feingold as a pediatric infectious disease specialist, and if Your Honor wants to hold off until she's qualified
Is
on the
that,
stand.
yeah, I would say, is that first name correct? A-N-A-T?
That is correct.
All right. Mr. Lucci, what do you say about that?
I mean, when she testifies, if she says that and she's qualified as that, I have no problem with it.
All right.
The only thing I would add, though, is the state and the defense called Raymond Coates as an expert.
Excuse me? I can't hear what he said.
The state and the defense called Raymond Coles as an expert.
Well, do we need to say that who called who? Or we could just say,
Well, we have that here. I just added it because you delineated it.
right, so that paragraph says, in this case, the state and defendant called experts to testify. Can we just say Raymond Coles testified as an expert in digital forensic examination and Dr. Andrews, et cetera, or do we want to say who called who?
It's delineated as who called who the way it is now. I would have to look at the model to see if it distinguishes as well.
Probably does.
And if the model distinguishes, I would suggest that we do the same.
You just say the state.
Both parties.
So the model basically looks like it gives you the option. The second paragraph of the model says, in this case, paren, list experts in area of expertise, or paren, state or defendant, close paren, or paren, state only, close paren, were called as experts, or called experts. So obviously that sentence needs work from the model.
Yeah.
So
Okay.
I could do either one. So you just have to split it up. The state and the defendant called Raymond Coles
Yeah.
as an expert. Then the state called Dr. Andrew and Dr. Feingold. That's what you want to say?
That's fine, Judge.
All right, so the sentence would then read, the paragraph would then read, in this case, the state and defendant called experts to testify. The state and defendant called Raymond Coles as an expert in digital forensic examination and analysis. The state called Dr. Thomas Andrew, a forensic pathologist, and Dr. Annette Feingold, a infectious disease specialist, and assuming she's qualified, we'll change that to a pediatric infectious disease expert. Defendant called Dr. Michael Baden, a forensic pathologist. That acceptable, everybody?
Yes, Judge, thank you.
Yes.
All right, so now on the bottom of 11 through 13 and the top of 14, we have 3 limiting instructions on deleted internet history or text messages, internet searches, and flight. If I could ask counsel to jump ahead to the flight charge for a moment on page 13. You see the last paragraph, the last sentence of that paragraph that begins with flight. Flight may be only considered as evidence of conscience of guilt if you determine that the defendant's purpose in leaving was to evade arrest or accusation for the offense charged in the indictment. Everybody know where I'm at?
Yes, Judge.
So the 2 preceding charges on deleted internet history and text messages and internet searches are essentially modeled after that flight charge. However, that sentence, or one substantially similar to it, is really not in the preceding 2 sections. I think I'm required to add something along those lines. For instance, deleted internet history or text messages can only be considered as evidence of conscience of guilt if you determine the defendant's purpose in deleting them was to evade accusation or arrest. Because that language is in the model charge. So I think it needs to go into all 3 of these sections, not just the one section on flight.
Had something else with regard to the
Right, I mean, there's a couple other
Yeah.
issues we need to tweak as well.
Yeah.
So. All right, so.
But I like the court's suggestion. Thank you.
All right, so then, in the section entitled deleted internet history, I'll have to add that sentence.
Where, Judge? I'm sorry, I was talking.
So in other words, the last paragraph of, strike that, the last sentence of the first paragraph of the flight charge, I think something substantially similar to that, although tailored to the deletions or the internet searches, needs to be added to the 2 prior limiting instructions. Because it talks about, in order to find conscience of guilt, you must determine that it was the defendant's purpose in doing something. So his purpose in deleting the messages, as opposed to he deleted them because his phone had too many messages. His purpose in deleting the message was to try and evade accusation, or his purpose in searching for can your phone be tracked in airplane mode?
I understand what you're saying.
All right. And do you agree that
So
something like that should be added to the 2 prior sections?
The last sentence on page 13 you want to add to the deleted internet history or text message and the internet searches. I have no objection to us crafting something.
All right. So so then for the deleted internet history or text messages, you can say deleted internet history or text messages may only be considered as evidence of guilt if you should determine the defendant's purpose in allegedly deleting the history or messages was to evade accusation or arrest for the offense charged in the indictment. And then for the internet searches, Defendant's internet searches can only be considered as evidence of consciousness of guilt if you should determine the defendant's purpose in conducting those searches was to evade accusation or arrest for the offense charged in the indictment. We'll put those in there and take a look at them. So then, any other comments or concerns with respect to this section that starts on page 11, deleted internet history under text messages?
Yes, Your Honor.
Go ahead.
So the first sentence says, there has been some testimony in the case from which you may infer that the defendant deleted text messages and or internet searches from his phone. That's true. There also has been direct testimony that from an expert that he did do that. There doesn't need to be an inference drawn by the jury. The witness said that that in fact did happen. So I think you have both instances. I think with his mom and his dad's text messages, yes, they can infer from the testimony because the witness didn't directly state that occurred. But with regard to phone calls with Ms. Michelow and the search for loss of consciousness, certainly the expert did give an expert opinion that that did in fact happen. They don't need to draw their own inferences about that. They're lay witnesses, they can't.
What do you say about that, Mr. Lucci?
Judge, I would object. I think once again you're steering the jury to look at particular evidence in the way that the state wants you to, wants them to. I think the charge is fine as is. Why would they make specific reference to evidence? That's their job.
So I got that language from the model charge on flight, though.
And I typically, directly to the issue of flight, I don't, you would be drawing inferences when it comes to that, but this was a little bit different. I mean, this was an expert that came up to testify about the issue, and they really can't, he said it was deleted. So I think it's okay the way that it is, but there should be a second sentence where there's no inference. And it doesn't have to talk about mom's text, dad's text, Brianna's text, loss of consciousness. I mean, there's so much. You don't have to distinguish the actual things that the defendant did. But I think in one instance there has to be an inference, and in the other there really shouldn't be an inference. They either believe it or they don't.
What do you say about that, Mr. Gallucci?
Judge, I'm objecting to the all of that. I think the model charge is fine as written. There's a reason why they write model charges.
Well, Judge, is this a model charge, or is this a charge that we created based on flight for this case, and it's tailored to this case?
So the flight, there's a model charge. These other consciousness of guilt issues are not models, but I tried to track the format of the flight charge in arriving at these, and I gave these already as limiting instructions, so the jury already heard me say infer.
And we agreed on that. And now the state is asking us to change it.
Well, I mean, that's why we're having a charge conference.
Right.
But and frankly, the state has significant evidence that things were deleted from the defendant's phone. So I think I'm required to use infer simply because consciousness of guilt is what gets inferred. So on the scheme of things, it's not a particularly monumental issue. I'm going to leave it the way it is.
Thank you, Your Honor.
All right, so then the next section, there's actually just a typo on 12. There's to be a period at the end of the first sentence of the second paragraph. It's the same sentence Ms. Schroen just talked about. So, Mr. Gallucci, right after that, although he's not required to do so, defendant may provide an explanation for the deletions. Do you want to leave it like that, or do you want to suggest explanations?
Can I think about that, Judge?
Sure.
There's going to be, that may be the defendant testifying.
I mean, I'm fine with the way it is, but, the flight charge, for instance, which is the basis for this, has an option the defendant could offer explanations for leaving the area. All right, then, Next section, internet searches, that's on 12 and continues on to after 13. The third sentence, we want to change that, and that this occurred after the dates set forth in the indictment as opposed to date set forth in the indictment.
Where are you looking, Judge? I'm sorry.
Page 12, internet searches. The end of the first sentence, so it's the third line. And that this occurred after the date set forth in the indictment. You want to change that to plural, dates? Or
It's really occurred after the later date set forth in the indictment.
Yeah.
honor after, because it's really the same day.
That's correct, Your Honor.
Yeah.
Judge, I don't have an objection to that.
Objection to
What?
occurred on or after or on or after April 1st? Or, I'm sorry, April 2nd?
Yes, Judge.
That works? This occurred on or after April 2nd? All right, so we'll get rid of date set forth in indictment, just put on or after April 2nd. April 2, 2021. Any other issues with the rest of that charge? On 12, after 13?
No, Your Honor.
No, Judge.
No, you're right. And in paragraph, the third paragraph, once again, I may want to answer that depending on what happens going further.
Very good. Middle of page 13, flight. Again, the second paragraph, the defense has suggested the following explanation, namely that it was being threatened. So we did that at the time. I gave the limiting instruction to the jury. Do you want that changed, or do you want to go back to what we said in the other ones, that although not required to do so, the defendant may offer an explanation? Mr. Galucci.
Judge, I think you should leave it the way it is.
Okay. Okay with the state?
Judge, is there evidence in the case at this point that he was being threatened?
At the time for flight.
There has to be evidence in the case. Can't just put it in through the jury charge.
I think the father testified to it.
He did? In front of the jury?
Well, I ruled that Carolyn Greger had testified that there was a threat of charges, but then Carolyn Greger didn't testify. I can't remember if Mr. Greger actually said that. He may not have actually said that.
Your Honor, I have the transcript if we need to reference any particular portions for that.
I actually have it now too, but I'm just
Okay.
on my notes. David Greger ever really testified to that in front of the jury, Mr. Gallucci.
Okay.
About Brianna, was she cross-examined on that? Brianna Mitchell?
She was cross-examined on it.
Yes, but it was in August what Brianna Mitchell did.
Well, the municipal court charge
Yeah.
was more in August, right?
Yeah.
But she testified as to going to the house, that she had done a number of things at the house.
That was afterwards, though, too, Judge. It's the time frame.
Right, it's not while he's in Arkansas. All that's really there from David Greger is about the defendant's travels after Corey died.
Gave that charge already, right? When the flight came out.
Right, because we thought there was going to be testimony about threats at that time.
Did Mr. Gallucci suggest that in his opening?
I don't recall.
Probably. That's what I'm looking at. Judge, in Ms. Michelot's first transcript, page 142, at line 7, it's they address the incident about throwing objects, but that's months later. So it doesn't address threats right after in the cross of Ms. Michelot, from what I can see, but I'm still looking.
I'm looking through the cross-examination.
Yeah, the whole conversation about the goldfish from the supermarket. I don't see it. I reached the end on the second day, and I just don't see it.
All right, still going. Page 142,
The first one, Your Honor? The first day?
April 30th, 2024.
Okay.
It actually starts on page 141 on the bottom.
Uh-huh.
There's no dates there. It talks about after Corey passed, did you and your mother and two other people have occasion to go to Christopher's parents' home, and then it continues about throwing goldfish or eggs on page 142, all the way down to the bottom. Goose eggs or goose egg stones.
Yes. That was in August, Your Honor.
I know, but there's no dates in that section. And then on page 143, which goes on about, did you then start a GoFundMe page?
I think then that it shouldn't say threatened, it should say through dead fish and eggs.
I think it was established through the father's testimony.
The dates that happened?
I have to look back.
Let me go back.
Right, Mr. Gallucci ultimately went to use the charge against Ms. Micciolo. It's not a crime. So I told the jury, we don't know what this is at this point. It's the first I heard of it. It's like a municipal court matter. He said he's going to get the transcript. So in terms of the August dates, that came out in front. That came out by
The father.
Right,
Mr. Greger's testimony.
Right.
David Greger's testimony.
right, that it would, so then it's put together that that incident was in August.
So what do you say, Doug? Any evidence that the defendant was being threatened, Mr. Lucia, at the time he left New Jersey?
Judge, I have to agree with the prosecution that when the mother didn't testify after a phone call, that she didn't testify about the threats. But I thought that the cross-examination did lay out, of Brianna, did lay out that they had gone to the house. I mean, throwing goldfish and rocks in the house, to me, is threatening. I mean, maybe to somebody else it's not, so.
Right, but it's got to be at a time frame that's relevant to the flight.
Well, then, why don't we just add, the defendant suggested the following explanation, that after he was stopped in Alcoa, Tennessee, and wasn't arrested, he came home, and then wasn't arrested for another 3 months and stayed at home.
Except for when he was traveling.
Or do you want to make it consistent with the prior to on the deletions in internet history, although not required to do so, the defendant may provide an explanation for his actions. We don't say defend, you could say defense even, although not required to do so, the defense may provide an explanation for the actions. That gives you the ability to say whatever you're going to say in your summation.
Right.
What do you prefer?
Not defendant, because I think now you're putting that onus on him.
Right.
I think that's fine, Judge. I would agree to that.
And it's consistent with the other two.
Yep, I would agree to that.
The state agrees as well, Your Honor.
Although not required to do so, the defense may provide an explanation. For those actions. All right, any other issues with the flight charge? Page 13, halfway down, page 14.
No, Judge.
So the middle of 14 then brings us to the third part of the instructions, which are those portions of the criminal code applied to the case. Count 1, endangering second-degree crime should be deleted. You don't tell the jurors the degree, so I'm going to cross that out. Everybody agree with that?
Yes, Judge.
All right, so the model charge is lengthy. My law clerk also provided us a copy of the model charge. Again, we're going to change references to the child's initials of CM to Corey, right?
Yes, Judge.
So the state has the burden of proof. So let's start with the state. What sections of the definitions of abuse, cruelty, and/or abused and neglected does the state seeking to rely upon? Because I don't think all of these can stay in here. Some of these do with depriving the child of education and making the child work in a particular employment injurious to health. So obviously many of those things are not applicable.
I would like this whole paragraph.
Judge, yeah, so the state submits that the first paragraph, the abuse of a child, the first one listed is really not relevant to the.
I certainly agree with that. So then, obviously the pagination will change, but what's currently on the top of 16 then, cruelty to a child, out of those definitions, which ones there do you want?
Judge, the state would submit that all of those could apply in terms of the cruelty portion of it.
Mr. Glucci, you know where we're at?
I do, Judge.
So what do you think of that cruelty section?
I disagree with C.
C is, quote, habitually tormenting, vexing, or afflicting a child, end quote. What do you say about that, Ms. Monto?
Your Honor, I think the jury can infer what it wants to infer in terms of the defendant's conduct. So, I mean, we have a video of the defendant abusing the child on the treadmill, and we also have videos where you could see him, what happens before and what happens afterwards, that he's walking out into the street, not paying attention to him, not holding his hand as they go into the street. So I would say that is a question for the jury to determine. It's not something that's so not applicable like the first section of it that could be within the jury's purview of finding.
Judge, I don't think they proved habitually. But because he didn't hold his hand walking out of the gym?
No, I'm not talking about that. I'm talking about the totality of conduct, and that was an example that I was using.
Judge, I don't think C is applicable.
And he let him fall 6 different times, too.
And that's one incident.
I don't know if that's habitually, though. I guess that's the objection, is that habitually? I mean, if they're going to convict him, they're going to convict him based upon these other sections, not based upon subsection C, so.
So, I mean, again, I would argue that having a child fall 6 times, place your mouth on his head, when you look at that, even within the context of the day, that could be found. So that's the state's argument, Judge. We would defer to the court.
So the model charge provides a certain paragraph on cruelty. Quote, cruelty to a child shall consist in any of the following acts. A, inflicting unnecessarily severe corporal punishment upon a child. B, inflicting upon a child unnecessary suffering or pain, either mental or physical. C, habitually tormenting, vexing, or afflicting a child. D, any willful act of omission or commission whereby unnecessary pain and suffering, whether mental or physical, is caused or permitted to be inflicted on a child. E, or exposing a child to unnecessary hardship, fatigue, or mental or physical strains that may tend to injure the health or physical or moral well-being of a child. Courts of the view that sections A, B, D, and E are appropriate because the evidence provides a rational basis for the jury to find those sections. I don't think it adds anything to the state's case to have C in there. Habitually, in this court's view, means more than the couple of minutes of putting the child back on the treadmill. Afflicting doesn't really apply. So in all fairness, I find it's appropriate to delete C, and then any objection if I renumber D and E then?
No, Your Honor.
No, Judge, thank you.
All right. And so then it'll be subsections A, B, D, and E renumbered to an A, B, and a new C and D. And then how about the section below that, abused or neglected child means? You want any of that or no? It seems to me that it's not really applicable, but.
No, Judge.
I don't understand, Judge. You're finding that that should be taken out, number one?
I didn't know if you wanted any of that.
That the defendant inflicted or allowed to be inflicted upon such a child physical injury by other than accidental means which causes or creates a substantial risk of death or serious or protracted disfigurement or protracted impairment of physical or emotional health or protracted loss or impairment of the function of any bodily organ. I mean, I think that has to stay in there. That's the definition of abuse and neglect. Right? Because there's cruelty, which is a form of abuse, and then there's abuse. And then
Oh,
there's
I see what
also,
you mean,
right,
I see what you mean. So, yeah, so the elements of the offense are that Corey was a child, that the defendant knowingly caused the child harm that would make the child abused or neglected, that the defendant knew such conduct would cause the child harm that would make the child abused or neglected. Defendant had a legal duty to care for the child or assume for the responsibility for the care. So that's got to stay in, Mr. Bellucci, because
That's part of the abused child definition.
Right. All right, so, but still the choose is appropriate, so which ones?
Judge, the state submits that all of them are appropriate because underneath the endangering statute, those would all be appropriate definitions regarding what could be considered child abuse. It's you are inflicting or you are creating or the child has been impaired, either physical, mental, or emotional, or is in imminent danger of becoming impaired. So all of those specific circumstances would apply, and that is the definition of what an abused or neglected child is. The state does not have to prove actual injury. All of these different sections do apply, and the state would submit that they are appropriate for the charge.
So the state's argument is the child was subject to cruelty, which therefore renders him abused or neglected within the meaning of what's on page 16.
Judge, I disagree. I understand number one, but number two, as for an ongoing risk, I don't see an ongoing risk. I don't see number three. Number one, I believe is appropriate. I disagree with two and three.
Your Honor, what it reads is allowed to be created a substantial or ongoing risk. So it's either a risk then or an ongoing risk. And then number three, that is a definition. A child whose physical, mental, or emotional condition has been impaired or in imminent danger of becoming impaired as a result of the failure of the defendant to exercise a minimum degree of care. So, I mean, those are all of the sections, and as the case has been tried and the facts put before the jury, that would be the jury's decision in terms of what they find. To somehow take out the definitions of that and not charge the jury about that is not appropriate. There's a rational inference for all of those things, Judge, just on the basis of the treadmill, and that would be the state's specific argument.
All right, defense counsel agrees that under abused or neglected child, subsection 1 is appropriate. The court finds subsection 2 is appropriate because there's evidence which allows a rational basis for the jury to conclude the defendant created or allowed to be created a substantial or ongoing risk of physical injury to the child by other than accidental means. So the court finds both substantial and ongoing are present in the evidence such that the jury could find that. The treadmill video shows the risk of a substantial injury. It also shows an ongoing risk because the child is required to get back on the treadmill multiple times. There's also a rational basis to believe that that incident could have caused death or serious injury or protracted disfigurement or protracted loss or impairment of the function of any organ. With respect to C, there's one typo in there. So if you look in the model charge, there's a subsection A, which the state chose not to submit, which is appropriate to delete it because that deals with supplying the child with adequate food, clothing, shelter, education, and medical care. So then you'll see in the proposed charge is a subsection B, but we need to delete the B since there's no A. You follow me?
Yes,
Yes, Judge.
So that should come out. So then the state seeks, under abused or neglected, subsection 3 to read, a child whose physical, mental, or emotional condition has been impaired or is in imminent danger of becoming impaired as a result of the failure of the defendant to exercise a minimum degree of care in providing the child with proper supervision or guardianship by unreasonably inflicting or allowing to be inflicted harm or substantial risk thereof, including the infliction of excessive corporal punishment or by any other acts similarly serious, of a similarly serious nature requiring the aid of the court. The court finds that there's a rational basis for that based upon the treadmill video, Mr. Gucci. I mean, some of those obviously overlap, but just with the deletion of paren, lowercase b, closed paren, I find that there's a basis in the evidence for the state to be able to have that charge to the jury. All right, so then the balance of the charge continues with instructions on knowing and knowingly as a level of culpability. So any issues from the bottom of 16 through the end of the charge on endangering the welfare of a child, which is on top of 18?
No, Judge, thank you.
Then we're on count 2. Count 2 starts on page 18. This is after the model charge. So the court notes that there's a model instruction for lesser included offenses, but it specifically says not to be used in homicide charges. And the judiciary has developed a model charge for murder, aggravated / reckless manslaughter, and this pretty much tracks that model charge. Again, we agreed to change CM to Corey, right?
Yes, sir.
Yes, Judge.
So starting with count 2 on page 18, any objections or concerns about what's on page 18?
No, Judge, thank you.
Charge continues on 19. It did have one issue. The second paragraph, which is lengthy, 4 lines up from the bottom. Such things as the place where the acts occurred. Everybody following where I'm at?
Yes, Judge.
Tell me when you find it, Mr. Gucci.
Where are you, Judge? Page 19?
Page 19, the second paragraph, 4 lines up from the bottom of the second paragraph. Such things as the place where the acts occurred.
Okay, I'm there.
Comma, the weapon used. Comma, the location, number, and nature of wounds. It was concerned about the weapon used.
There is no weapon used.
And there's no evidence of a weapon.
No.
I think you need either the weapon used, if any, or some clarification. This is not a shooting case, for instance, where there's a doctor testifies the victim suffered from gunshot wounds, where it's obviously there's a weapon used.
So, Judge, you want to leave in the sentence, such things as a place where the acts occurred, and then just skip to the location?
I think that's probably appropriate.
Judge, I don't disagree with that.
All right, so we'll cross out the weapon used.
Yeah.
All right, any other issues on that page?
No, Judge.
All right, page 20. We've highlighted for you a section in the middle, which we'll talk about for a minute. So anything from the top of 20 down to that highlighted section have any concern?
No, Your Honor.
I just wasn't sure, Judge, in terms of the factual theories of causation.
Right, so that's what I wanted to discuss. So
Right.
that's going to appear for murder, aggravated manslaughter, and manslaughter. So we've highlighted that in this draft for the charged murder count and the 2 lesser included aggravated manslaughter and reckless manslaughter counts. So when the model charge contains the following statement: when the defendant and state offer contrasting factual theories of causation, each version should be summarized for the jury. So here you have, right? The state says blunt force trauma, the defendant says sepsis.
Natural.
Natural causes.
All right. So we want something right. Here the state alleges X, in contrast the defendant alleges Y. Something as simple as that?
That's fine, Judge.
All right, and what do you want to say? Here the state alleges Corey died from blunt force trauma. In contrast, the defense alleges Corey died from natural causes.
Yes, Judge, we have something written down like that that's pretty similar, so we have no objection to that.
Oh, I'm sorry. I guess we tailored what you submitted.
Oh, no, Judge, I just mean from us speaking
Oh,
last
okay.
night about it. I apologize. No, I'm saying that we're fine with that. Thank you.
And that'll be for all 3 homicide counts, or homicide count and 2 lesser included?
Yes, Judge.
Add that to the document, but it will essentially be, quote, here the state alleges Corey died from blunt force trauma. In contrast, the defense alleges Corey died from natural causes. So from that highlighted section on 20 to the remainder of the murder count, any issues there?
No, Judge, thank you.
And then on 20, the charge then transitions to aggravated manslaughter. We'll put that same language in. Any objections, concerns with the aggravated manslaughter portion of the charge?
No objection from the state, Judge.
None here.
On 22, the charge then transitions from aggravated manslaughter to reckless manslaughter. Again, with that addition about the competing theories of causation. Any objections from 22 to the middle of 23?
No objection, Your Honor.
All right, so that now we're at the end of the third portion of the charge, which is on those portions of the Code of Criminal Justice which are applicable. We begin the fourth part of the charge, which is on deliberations and some other matters. The section on deliberations is from the model charge. If you go to the second to the last paragraph on the bottom, the model charge says you must keep any cell phone or communication device turned off. I just was going to modify that. You must not have any cell phone, pager, or other communication device with you in the jury room.
That's fine, Judge.
All right. Any other concerns about the deliberation section?
Your Honor, it looks fine to the state. It appears to be the model. There's no objection.
Thank you. All right, then on 24, there's a very short section on a unanimous verdict. And then right below that, a written copy of the jury instructions. Both of those are models. What I do, Mr. Gallucci, whatever the final charge is marked as court exhibit. So right now it's C13. We'll probably do a 14 just so we have a cleaned up one. After I read the charge, when we're done, I ask counsel to come to sidebar. At that point, I ask are there any objections or concerns. And it seems like I always notice a typo when I'm reading it to the jury, so we may correct the typo or something like that. And then if everything's acceptable, then we make 2 additional copies from that point, label them C14A and C14B. The A and B are the ones that go in the jury room, rather than make copies in advance and then you have to change everything.
No, that's fine.
All right. So any problems on anything that's on page 24?
No, Your Honor.
No, Judge, thank you.
Page 25 talks about the verdict sheet, which we're going to talk about in a minute, but then subject to discussing the verdict sheet, any issues about what's on 25 and just the top of 26.
No.
All right, so what I add on 26 at the first full sentence on that page, if you have reached a unanimous verdict, comma, knock on the door, what I add is, if you have reached a unanimous verdict on each charge, write a note saying, quote, we have reached a verdict, close quote, knock on the door and let the officer know. But I'm walking out saying we've reached the verdict, I want to write a note, we have reached the verdict.
Yes.
All right, so I'll add that there as well. All right, when you go to the verdict sheet.
Thank you, Judge.
Take a brief recess.
Is it the one?
All rise. You know, this causation, the state is saying blunt force trauma, and I agree to natural causes after speaking to Mr. Greger, and I kind of agree with him. I'm sorry, Judge. And I kind of agree with him. You know, you don't generally see a child dying from natural causes. So would it be, we would prefer if we said what Baden's going to testify to is the onset of pneumonia and then sepsis.
The state objects. It specifically talks about causation. So there's cause and manner of death. We all know that. And there's 5 different causes of death. Or there's a number of causes of death, but one of them is natural.
Manner of death.
Manner of death, yeah. So what
I'm
Dr. said is
using my words.
Suicide,
Yes.
homicide.
Correct.
Natural, accidental, or undetermined, I believe, were the
In fact,
5.
I'm going to take out blunt force trauma and say murder and natural causes.
Sure, we'll say murder.
Well, but you said you were concerned about natural causes. You want to leave natural causes in there then? Or?
Well, if she's arguing that it's got to be the 5, one of those 5, I mean, I was just saying that if they're going to say blunt force trauma, why can't we say, what Baden's going to testify to, the onset of pneumonia and sepsis?
I mean, certainly going to say that in closing.
Right, well, absolutely going to say it on my closing.
Well, if
I would hope.
I shouldn't say murder, I should say homicide then, if I'm going to pick.
Well, Judge, I mean, the onset too, like you're putting facts into the case. In terms of cause of death, it's blunt force trauma injury. The defense is arguing that this is a natural death. I don't know as a simpler way to say that. Like, what the purpose of that is just to give an idea to the jury. It's not to impose the defendant's argument or their proposed testimony into the jury charge.
That's fine, Judge. Then we don't have to impose on the jury blunt force trauma.
So it's just homicide versus
Natural causes.
No, Judge, I believe that our cause of death is blunt force trauma. Their cause of death is
Sepsis.
sepsis. So you want to say sepsis? Then we could say we don't have an objection to the word sepsis, but I think it's onset of pneumonia is where we start getting into that.
I personally don't see the difference. But, I mean, the two go together. You're not going to get sepsis if he didn't have pneumonia.
That's not true, Judge. Sepsis, there's a lot of different things that can be caused by sepsis.
He's not saying it's any other infection other than pneumonia.
Well, then we'll just go with what state says it's a homicide, and then he says it's natural causes, because the state does not think it's fair that he gets to put his argument into the jury charge. There's many different things that could happen because of sepsis, and that's but it's blunt force trauma injury. That's our cause of death. It was testified as to an expert. He shouldn't be allowed to put his argument into the jury charge. Right, the state's not asking that we put lacerations and all of this. It's just blunt force trauma.
So the model charge entitled murder, aggravated/reckless manslaughter, class revised June 13, 2011. 3 of the model talks about where there's a causal relationship. If there's no causal relationship, there's no dispute as to the causal relationship, or a causal relationship is not an issue, such as you have a shooting case and we all agree the person was shot and killed. It's just a question of, is the defendant responsible for that? You don't have to have a special section on causation. Here, that's not the case. So we have the section before this, it's a top of 20, causation has a special meaning under our law, and then we describe what is known in the law as, quote, but for, end quote, causation, meaning but for the defendant's conduct, Corey would not have died. And then the model continues. There's a section on whether someone's removed from life support. That would be not applicable here. And then the model has a bold-faced section in parentheses where the defendant and state offer contrasting factual theories of causation. Each version should be summarized for the jury, and it cites a case. State versus Martin, 119, New Jersey, 2 at page 18. So let's see what Martin says. So Martin appears to require a section which is incorporated into the model charge, because this Martin case is from 1990. Here, the court had failed to instruct the jury the defendant would not be liable for felony murder if the death was too remote, accidental in its occurrance, or too dependent upon the volitional act of another, which is all that's already in our charge, right above that. Let's see what else the case says. The court there, this was an arson case. The defendant's alleged to have set fire and whether or not he's responsible for the death. The court in Martin said a further deficiency was the failure of the jury charge to relate the conflicting factual versions to the legal issues. Causation, like criminal knowledge or intent, is often a nettlesome proposition to explain to a jury. The explanation, however, is essential if the jury is to apply the dispositive legal principles to the facts. And it cites some case law. Otherwise, a jury may not be able to evaluate the facts under the appropriate legal standard and thereby determine whether the defendant is guilty of the crime charged. It is not always sufficient simply to read the applicable provision of the criminal code, define the terminology, and set forth the elements of the crime. Particularly when the trial projects conflicting versions of the facts, the court should mold its instructions to the factual hypotheses of the parties. An abstract statement about causation or the defendant's state of mind is not nearly so useful as one stating the same idea in the context of the various factual alternatives projected by the parties. Unfortunately, in attempting to explain causation and the defendant's possible mental state, the trial court failed to explain how the evidence could affect those elements. I read from the case, although I did omit various citations. So here we clearly have a disputed causation. This is unlike many murder cases where there's no dispute as to causation. The question is the defendant responsible, or did the state prove the defendant's culpability beyond a reasonable doubt? Here we have that issue, but we also have, is it even a homicide? So, I mean, as long as I couch it in terms of the state argues X and the defendant argues Y, I'm not drawing either side's attention to some particular evidence, as long as I'm doing it on balance. But it would seem you're both entitled to do that here, and I don't think you need to limit it to the 5 manners of death. The state alleges homicide, the defendant alleges natural. I don't think you have to be that brief.
Judge, I think Martin specifically actually says that. It says even in the absence of a request by his trial counsel, the defendant is entitled to a charge consistent with his version of the facts.
Right, and that's probably why the model was then amended to add this language that you have to tailor it to the facts of the case, particularly in a case like this where causation is an issue.
Judge, when we were talking about it before, defense counsel agreed that's how it was going to be done. If we're going to do it another way and we're going to be able to provide a statement, then we're going to have to request that we're going to have to write something and submit it to the court then, if we are allowed to give a broader explanation.
Keep in mind, you're both going to be able to argue in
Right.
your summations what you think the evidence shows.
Exactly. But we just want to make sure that it's balanced, Judge, as what the case law says.
I think you should both try and work on a joint statement then. You know what, each know what the other one's alleging. So I'm fine with here the state alleges who he died from, whatever you claim he died from. In contrast, the defendant alleges who he died from, whatever you claim he died from. As long as there's a rational basis in the evidence or the testimony to say that, I'm not directing the jury's attention more heavily to one side or the other.
Right.
But I was kind of hoping to be able to give you a final version here today, so, but we still have plenty of time if you want to do that. You want to move on to the jury verdict sheet and circle around back to this later on?
Whatever you want, Judge. I'm here all day.
All right. All right, so let's
Why not? That's true.
for the next. We'll strike that. Let's just mark the verdict sheet as C14 then. And then we'll have the jury charge, final jury charges, whatever it is. Everybody say,
Yes, Judge, thank you.
any objections to question 1?
No, Judge, thank you.
No, Judge. Judge, the only thing is, Mr. Gregor also mentioned on the break, it was a nice break, that he would like endangering the lesser included, third degree also included.
The third degree is inapplicable because there's a duty of care and there's specific case law as to the fourth degree that it's really the state's election out as how to proceed. So in both of those circumstances, it would not be applicable. He has a duty of care of a father, so he's not eligible to have the third degree. Thank you.
All right, so with respect to the endangering the welfare of a child, it's a third degree crime unless the defendant has a legal duty to care for or has assumed a duty to care for the child. In some cases, you have a close call about whether someone assumed a duty, say they're a babysitter, they're only there for a short period of time. But for a biological parent, particularly in this case where we have testimony regarding custody orders, and the defendant was the primary residential parent, that term was used in a variety of different ways, custodial parent or something like that, and was residing with the defendant, going to school and Barnegat where the defendant lived. So the defendant clearly had a legal duty to care. There's no rational basis for the jury to find that the defendant didn't have a legal duty. However, I think we need to talk more about the fourth degree.
Yeah, there's case law, Judge, that we've submitted in other cases. It's really prosecutorial discretion. The state did not indict or move under that section, so it's not a lesser included, and the state has elected to go ahead with the second degree. When we leave today, I could go back to my office and supply the court with a packet in regard to the case law. I did not bring it with me today, as I did not know that there was going to be objection, but there is quite some case law about that issue.
Judge, that's fair.
Yeah.
I think that's fair.
All right.
Give us both an opportunity to take a look at it.
Yeah, I mean, it's the state's, it's purely within the prosecutor's discretion to move under a second degree or a fourth degree. Listen, that's our decision, and with that being said, you can't ask for a lesser included of a fourth degree, my understanding, based upon the case law, and the third degree would not apply.
Okay.
So,
I'll circle back with Ms. Lento.
thank you, Judge.
Yeah, I would feel more comfortable if you do, in fact, place that case on the record before we finalize the charge. So I appreciate that from both sides.
Thank you,
Thank
Judge.
you, Judge.
To 2C:24-4, there is some language to that effect. The New Jersey Supreme Court has explained that the overlap between New Jersey statute 2C:24-4 and Title IX offenses allows the state to decide under which statute to pursue the alleged offender. The prosecutor's discretion in that regard, however, is not unlimited and subject to review under an arbitrary and capricious standard. State v. Fakwa, FUQUA, 234, New Jersey, 583 and 596. A 2018 case, which relies upon some other cases, including U.S. Supreme Court case, is when an act violates more than one criminal statute, the government can prosecute under either, so long as it does not discriminate against any class of defendants. And the comment continues that courts have similarly ruled that there was no constitutional infirmity in the fact that 2C:24-4A, a second-degree offense, is substantially indistinguishable from 9:6-3, abuse and neglect of children, a fourth-degree offense, thus vesting the prosecutor with discretion to seek a conviction under the more serious provision. The primary Purpose of Title IX is the protection of children rather than the culpability of adults. And the purpose of the 2C provision is to permit the prosecution to bring the prosecution for offense carrying a greater penalty when the circumstances so warrant. The court should only intervene when the prosecutor's action is arbitrary, capricious, otherwise constitutes a patent or gross abuse of discretion. State versus DAV, 348, New Jersey, Super 107, 116, television case from 2002. And so if you both want to look at those things, that's towards the end of comment 1 to 2C:44-4 in the New Jersey Criminal Code annotated. All right, so if the jury answers question 1, they answer that guilty or not guilty. The jury answers question 2, murder, they answer guilty, that ends it. If they answer not guilty, then they would move on to aggravated manslaughter. If they answer guilty to aggravated manslaughter, that ends their deliberations. If they answer not guilty, they would move on to reckless manslaughter. Any objections to the way these are all laid out, Mr. Bellucci?
No, Your Honor.
I normally do, this is a matter of style, I guess, but so after murder, I would normally say, if your answer to question 2 is guilty, stop your deliberations, advise the jury you've reached a verdict.
We could, that's,
If your
there's
answer
no
to question 2
objection.
is not guilty, move on to question 3.
Yes, thank you, Judge.
I like the way it is.
All right, that's fine.
Thanks.
I mean, I'm probably going to tell them when I go over it. You know, if you answer guilty to question 2, then you're done. If you answer not guilty, then you go to 3. But all right, if you like the way it is, it's fine. All right, so C-14 is acceptable as is?
Yes, Judge.
Mr. Gallucci, what I often do is hand out to the jurors additional copies of the verdict sheet read it over while they're in the box, and then the sheriff's officers collect them, so we make sure only one goes in the jury room. Any objection, I do that?
Not at all, Your Honor.
All right. All right, so then everything in the verdict sheet is good, so C14 in evidence. The jury charge, Ms. Grimaldi has assisted us in making the revisions that we talked about. We still have this issue then as to the contrasting factual theories of causation. It's a little after 11. What do you want to do? You want to take some time and, I don't know if there's any need for us to come back this afternoon. You want to take some time now, go over it, or?
Sure, Judge. Like I said, I have a visit with Mr. Greger at 1 o'clock. So I'm here for...
Judge, we're unavailable. We have a witness preparation for this afternoon, but we can certainly discuss it now with counsel.
That's what I'm saying. It's only
Yeah.
11:05, 11:07. So if
Yeah.
you want to take a break for a few minutes, try and write out something, and we have an hour and a half, so.
Sure, Judge.
All right, so we'll take a break, try and write out something so we can finalize this and just make some progress today. So let me know when you want to come back out.
Thank you, Judge.
Thank you.
All rise. Please step out.
I don't know. No, he wants.
6 a.m., we're back on our record after a break, where counsel hasn't make any progress with respect to the contrasting factual theories of causation section on the homicide counts.
So, Judge, I recommended that we read right from Dr. Baden's report. The last sentence says, cause of death was Staphylococcus aureus pneumonia with resulting sepsis and seizure, and manner of death was natural. That's the last sentence of his report. I'm trying to pull up Dr. Andrews' report.
Your Honor, we actually looked at the testimony that was, so basically the state argues that Corey was murdered. Cause of death is blunt impact injuries of the chest and abdomen with laceration of the heart, left pulmonary contusion, and laceration and contusion of the liver. That is his direct testimony as to cause and manner, which is contained within the transcript.
So assuming Dr. Baden testifies to that portion of his report, do you agree that that is the
Well, I mean,
defendant's contrasting version?
Well, I mean, if Dr. Baden testifies to more than this, just like Dr. Andrew testified to more than here, then I guess I would increase my request.
All right, so we'll have to address this after Dr. Baden's testimony.
I
Why don't we have-
I mean, Dr. Andrew testified to more, but that's his express answer to the question of cause and manner.
So do you want to have a preliminary version, which is Dr. Andrews' testimony and that last sentence of Dr. Baden's report, subject to any revision after his testimony?
That would be fine, Judge. Thank you.
Judge, I think this should be addressed after Dr. Baden testifies.
Right, but I don't want to start drafting it from scratch then. I'd like to have it, a version now based upon what you anticipate, and then obviously if, I mean, you have a right to object to the charge up to the moment I give it, and even after I give it, I'm going to call you over the sidebar and ask you if you have anything
No,
to object
Judge,
to.
I understand all of that. I'm trying to make it easy for you. I'm not trying to be not easy. Yeah, I agree to that. That's
All right, so that'll be the preliminary section
Yes.
of the contrasting factual theories of causation with, obviously, the caveat that Dr. Baden has to get on the stand and testify, and whatever he says to the jury would be the section.
Right.
The information would be filled in there because the jury gets neither expert report, the reports are hearsay, the testimony is the admissible evidence. Right, so that's a mouthful for me, right? So do we have, I wasn't able to keep up, Ms. Romaldi, were you able to keep up? No. All right, why don't you give that to us again, Ms. Lento?
I wrote it. I wrote it in my notes someplace. You want me to just read it out?
Let me find it.
We could just, let me just read off of the language. The transcript, so we have the
Sure, actually,
specific
I can go ahead.
language.
Tell me which transcript we're at.
Dr. Andrew, 5824, page 12, line 6.
Line 6, yeah. So.
It begins with the
I
states.
don't think I have that one.
I can read it slowly.
We can
Your
read
Honor.
it slowly too, if you'd like
What is
again.
it?
Who?
It is Dr. Andrew,
Is that you?
page 12, line 6.
I thought she sent you everything.
She did send me, we just didn't see it. Let me look here.
I can send it to you, Judge.
No, I have,
The thing, Mr. Chairman.
5824. That's what the title says.
I have it.
Yeah, line 6.
Sure, what page is that?
Page 12, line 6.
So he actually quotes from his report. Corey died of blunt impact injuries of the chest and abdomen, laceration of the heart, left pulmonary contusion, and laceration, contusion of the liver.
Before that, you want the state to submit.
And then obviously, Judge, we'd want a part that the state submits its murder if defense wants to add that it was a natural death as to manner of death too.
And the manner of death was homicide then? Because Dr. Baden's report, Corey's death was Staphylococcus aureus pneumonia with resulting sepsis and seizures, and that the manner of death was natural.
Yes, I mean, I think it should be equally
Right.
balanced, right?
So you'll add, after the Dr. Andrews' statement that I previously quoted, and the manner of death was homicide.
Yes.
Right, just copy both of those and I'll put them in the charge.
Listen to the record.
Right, so I'll just read the cases too. Let's go back up and I'll put them on the record, state versus NA.
I'm gonna write it down real quick.
Yeah.
Turn it up.
Can you go back to
You one page right now with that language in it.
Thank you,
Take,
Judge.
look at that before we reprint out the 26 pages or so.
Thank you.
It's at the very bottom
Yep.
of what's marked page.
Here are the stamp. Laceration and the bruise. Yours too, because that's what happened. That's what happened. I mean, that's the cause of that. It's just found in his body. I have the case law too about the endangering. I'm going to let the judge know. Yeah, I'm going to put it on the record.
Okay, thanks. You can't give it to me before.
Well, I was just going to put it on the record.
Well, let's just make sure this is acceptable.
Okay.
Subject, obviously, to Dr. Baden's testimony, so.
Right.
Page 20, is that, the last paragraph, is that acceptable on the competing theories of causation?
Yes, Judge.
Right. Madam Clerk, could you mark that as C13A then? All right, so C13A, then will be the confirmation that at this point, subject to Dr. Baden's testimony, that language of causation is acceptable to both parties. Ms. Lento, you wanted to address the fourth degree versus second degree endangerment.
Yes, Judge. I was able to pull up some cases, during the recess. So the state would be relying on State versus NA. The site is 355 NJS 143 152 through 154. That's an appellate division case from 2002. And it stands for the proposition that of the fourth degree is not a lesser included of a second degree endangering. We would also be relying on State versus Figua, which the site is 234 New Jersey 583, and that's a 2018 case. And then State versus States, that would be 44 New Jersey 285, 1965. And in essence, Judge, the argument would be that it's really the same elements to prove both of them, so they can't be lesser included, and that way the state would have the discretion, and that's what really what Figua talks about. And then State versus NA is also applicable.
Mr. Bucci, you'd like to respond to that at all?
Judge, I'd like an opportunity to take a look at those cases.
And further along in the annotations in comment 3, under the Title 2C, look at the 2023 edition. The jury cannot be charged with 9:6-3 as a lesser offense because it would be impossible to acquit a defendant of 2C:24-4 but still convict of 9:6-3, and that's with a citation to State versus NA with the same pinpoint page numbers that Ms. Lento just provided. I'll give Mr. Gucci an opportunity to take a look at that. I'm certainly happy we spent this time doing this today rather than trying to do this Friday afternoon or Tuesday morning or something like that. So, because other than potentially exactly what Dr. Baden says, pretty much have all the evidence that we need to finalize the charge. What do you anticipate in terms of the state's motion to bar Dr. Baden from non-medical testimony, for lack of a better term, like the state's motion about what they call improper testimony? You anticipate having some hearing outside the presence of the jury, or?
He's an ME. He's a medical examiner. I'm assuming that he would be allowed to testify about what a medical examiner does and what he's done as a medical examiner and how he came up with his conclusions and the basis that he's basing his conclusions on and the documents he reviewed to base his conclusions on that and the slides he reviewed and the expert reports he reviewed and the ME reports he reviewed and the IV pediatrics. And I'm assuming, just like Dr. Andrews testified, that he went through all of these things and he came up with the conclusion that he, was an ME for like 20 years, that he comes up with his conclusions based upon X. I don't think he's going to testify as to what the state of the mind that Ms. Linto and Ms. Schroen are talking about. I think they're right. He's not allowed to testify as to what their state of mind is, but I think he's certainly going to be allowed to testify about how he came up with his conclusions and why he thinks the conclusions that Dr. Andrew came up with are wrong, and Dr. Feingold.
I think the concern is a slightly different area, though. That he opines Dr. Pregasa did not agree with the police opinion that it was a homicide, therefore the state looked for a second opinion, and the Pregasa rejected law enforcement requests to reconsider and change the manner of death. I mean, there's no evidence in the case that law enforcement made requests, no evidence before the jury that law enforcement made requests that Dr. Pregasa rejected them. No, nobody called Pregasa.
And like I said, Ms. Ferranti is working on a response.
All right.
It's going to be a 3-second conversation, if Baden was even going to discuss that, with me going out in the hallway and saying, we just had a hearing and you can't say X.
All right. That's fine.
I don't think it's something that we're going to delay the trial into Tuesday.
Well, that's another issue I kind of wanted to talk to you about. I don't know how long Dr. Baden is going to be, but you made a comment the other day that if Mr. Greger testifies, I think it's going to go to Tuesday.
If Mr. Greger testifies, Judge, I would assume, and I hate that word, Dr. Baden's testimony is probably going to be in the morning. If Mr. Greger testifies, I would assume that I'm going to probably take up a lot of the afternoon with him. And I mean, I'm not holding the prosecution up to, a time frame, but as a former prosecutor and somebody who's been doing this for 34 years, I would think that their cross-examination would be lengthy. And it's a Friday. So if he testifies on Friday, let's say he starts at 1:30 and he goes until 4. I'm assuming that that these young ladies are going to turn and say, Judge,
Right.
we've got a half hour, let's go into Tuesday. And if we're going to Tuesday, I would assume they're going to probably take up the morning, and then I have redirect. So it could be lengthy.
And Ms. Strong already indicated she thought cross-examination would be lengthy. My point, though, is we've been asking this jury to accommodate all of our unusual and unique scheduling problems and issues. I don't really feel comfortable keeping them here until 4 or 4:30 on Friday of Memorial Day weekend and tell someone to get on the parkway and sit in bumper-to-bumper traffic to get home to Little Egg or something like that. So I really thought about that. Of all days, I'm going to keep them till the end. I don't really want to keep them till the end of Friday of Memorial Day weekend.
Judge, we are 2 weeks ahead of where we were going to end this trial. 2 weeks ahead of the day that we had actually given. Although it's been abbreviated, and all of us in this room would probably agree with the fact that it's an unusual way about going through a trial. To nobody's fault. There's no fault. But I can't give you an answer as to...
I'm not asking you to give me an answer. All I'm saying is if your client testifies, my feeling is that we're not going to stay here till the end of the day on Friday. We're going to break earlier. If he's going to continue on Tuesday, he might as well continue on Tuesday with another hour or two on Tuesday rather than till the very end of Friday. I don't want to do that to this jury, have them get stuck in traffic and then be all disgruntled and bent out of shape out of us, because that's the one day we kept them. We had some full days of trial. We got done at 3 o'clock. So I don't really want the whole month, the worst day of the month, we make him stay till 4:30. So that's my thinking now, knowing that Baden can't go on Thursday, he has to go on Friday, and then rightfully so, you make the decision, your client makes the decision thereafter whether you're going to testify or not. So I'm just kind of giving you forewarning that whether we're in the middle of the direct or whether we're already started cross, I'm likely to say it's got to continue on Tuesday, earlier than 4:30.
Judge, I'm easy. Whatever you want to do, I'm good with. If you tell me, Mario, put him on Tuesday for direct and cross, I would do
We'll see how long Baden goes.
Yeah, I would do that. You've been wonderful. Anything you want to do, I'll do. I'm not arguing with you.
No, but I think we kind of left it that we're obviously not telling the jury that the defendant may or may not testify. They should know that until he ultimately makes the decision, the final decision. But I'm just trying to give both of you notice that I'm loath to keep the jury here late on a Friday of a holiday weekend, especially when we've asked them to jump through all these other hoops for us with respect to scheduling. That's the one day I don't want to hold them till the end. So.
That's fine, Judge. The state agrees. Thank you.
All right. All right, so anything further we can discuss for today?
No.
All right, so why don't we mark then the revised charge as, what's the next order, 15, Madam Clerk? So then C13 is not in evidence, that was a draft, and that's been chopped up. And then, at this point, any objection? I just emailed to you? You just emailed to both sides?
No, Judge, thank you.
We have that sentence about Baden that we have to finalize when he testifies.
Perfect.
All right, so we'll mark one copy as C15, which the court will retain, and court staff will email counsel for both sides a copy of C15. Somebody refresh my recollection. You tell the jury report at 9 tomorrow? Or you tell me report a little bit later? 9:30. And you anticipate your witness is going to be available at 9:30?
Yes, right. Yes,
Yes.
Judge.
All right. Any issues with that witness that we need to address outside the presence of the jury that anyone's aware of? All right. So I'm going to guess that you probably don't anticipate going a full day tomorrow either, right?
Judge, I
No,
can
Your
tell
Honor.
you that my cross-examination is going to be de minimis, if at all.
All right. So then, by way of summary, tomorrow morning only, no trial Thursday, come back Friday morning with Dr. Baden, and then the defendant makes his decision after that.
Yes, Judge, thank you.
All right. So then I guess tomorrow, depending on what time we get done, if Ms. Ferranti has submitted a brief, we can then discuss the state's motion.
I'll talk to Ms. Ferranti this afternoon about how she wants to proceed, and I'll get in touch with my co-counsel and Ms. Romali. But I don't think that is I don't think that's going to be an issue.
All right. Any further for today?
No, Judge, thank you.
Thanks so much, everyone. Appreciate you being here today.
All rise. Please step out.